Good morning, everybody. Welcome to the Law News Network, and thanks for joining us. I'm Jesse Weber. We have a big day today. We're covering three big cases here: the Luis Toledo case, the Jeffrey Willis case, and the Adam Matos case. Let's begin with the Luis Toledo case. That is going to be our priority today. We're going to focus really heavily on that because we are in the death penalty phase of that case. But here's what happened. Luis Toledo, 35 years old, last week he was convicted of second-degree murder in the killing of his wife Yesenia Suarez, as well as first-degree murder in the killing of their two children. Well, Yesenia's two children, Talia, who was 9 years old, and Michael, who was 8 years old. The bodies of all three have never been found, but despite that, there was such a heavy amount of evidence brought forth by the prosecution that the jury was able to convict Mr. Toledo of all three crimes, including also tampering with evidence. Now it becomes, should he be sentenced to death? Should he be sentenced to death because of killing those two children? We're going to talk about that in a little bit. Also, we are covering the Jeffrey Willis case out of Michigan. Jeffrey Willis is on trial for the murder of Rebecca Blech. He's accused of shooting Miss Blech several times in the head alongside Automobile Road in rural Muskegon County, Michigan on June 29, 2014. It was believed that she was jogging at the time. Now, the motive put forth by the prosecutors is that Mr. Willis wanted to kidnap, sexually assault, and ultimately kill Blech, as they claim he's done in the past to another woman, Jessica Haringa. Now, Miss Haringa disappeared from her gas station job in April of 2013. Her body has never been found, and he has been charged in the killing of that woman. That is going to be a separate trial, but that doesn't end it for Mr. Willis, because he is also charged with the potential abduction of a teenager. She was a 16-year-old. She was walking along a rural Muskegon County road in April of 2016. She escaped her abductor, and in court, I believe last week or the week before, she positively identified Mr. Willis as her abductor. All of these cases are being brought into this trial of Rebecca Blech, and we saw something very interesting yesterday. Mr. Willis actually took the stand and denied the accusations put forth against him. Very rare. We have to analyze that as well. Finally, one other case that we're covering here on the Law News Network is the Adam Matos case out of Pasco County, Florida. This man has been accused of brutally murdering his ex-girlfriend, Megan Brown, her two parents, Gregory and Margaret Brown, as well as her boyfriend, Nicholas Leonard. Brown, as well as Matos, they shared a son together, a 4-year-old little boy. If he is convicted in this crime, he faces the death penalty. Jury selection begins again at 9 a.m. today. We're waiting for the Luis Toledo case, the death penalty phase of that, again at 9 a.m., and the Jeffrey Willis case will begin at 9:30 a.m. And for anything that we're not covering here, you can go to lawnewz.com and watch, but our focus today right now will be Toledo when it starts up. And we have so much to discuss with all of these three cases, Ben. It's not good enough. I can't talk about it myself. So we're joined, so luckily to have us with us, is prosecutor and trial attorney Wendy Patrick. Wendy, great to see you, and thanks for coming on to talk today.
Thanks, Jesse. Always a pleasure.
Let's talk about Luis Toledo, okay? First of all, last week when the verdict came down that he was convicted, he said to the judge, I want to waive my right to mitigation, meaning I don't want to battle this out about the death penalty. Just convict me. Just sentence me to death. I want to die. And the judge said, you might be having an emotion here. You want to speak with your attorneys. Well, he must have, because he changed his mind and now he's fighting it. What do you make of that?
I think it's somewhat unusual, but not unexpected that he would change his mind. And the reason I say that is his lawyers probably advised him that despite selecting a death-qualified jury, that's the term of art that we use, sometimes when it comes down to it, jurors, when they have to balance grace and justice, oftentimes have a soft spot for something that's presented in the mitigation phase. And good lawyers want an opportunity to do that. You know, I started my career as a criminal defense attorney, and sometimes, as we say, you want to make sure you save your client from themselves, making sure that they get every benefit of the doubt and that they take advantage of everything the criminal justice system has to offer in terms of making sure they have a fair trial. So whether or not those jurors were found to be death qualified when they were selected, there's still going to be an opportunity to present mitigation. Now, this is the same jury that convicted him. Do you think that statement that he made, that I want to die, will that be used against him in this phase? Because here's the way that I saw it, okay? Here's a guy who first denied having any involvement in this crime. I mean, he admitted to killing his wife but said it was an accident. So he denied having anything to do with the children,
tried to put the blame on Tyshawn Jackson. That didn't work. As soon as he's convicted, he goes, just kill me. It seemed like a defeated answer, right? If I was the prosecution, couldn't you say, here's a guy who made us go through an entire trial. He knew what he did, and as soon as he got convicted, he felt his guilt and wanted to be killed. Can you say that?
You know, prosecutors have to be very careful that they only comment on the evidence. We often have our own theories as to what goes on behind the scenes and why did he put everybody through this trial. But making it just about the evidence, one of the things it does is first of all, it's the right thing to do. Second thing it does is it prevents the years of litigation of appeals as something improper that was said. So by focusing on the evidence, remember, Jesse, the jurors are thinking up this by themselves. And, you know, jurors always like to think that they came up with it themselves, and it's more powerful if they believe that, rather than holding it against the prosecutor for emphasizing something that's got nothing to do with any evidence that came out in the courtroom.
So what you say may not always be used against you. Let's talk about these aggravating factors.
Yes.
Because in a death penalty phase, you have aggravating factors and mitigating factors. The aggravating factors so far are that Mr. Toledo killed young children. He killed them because he wanted to avoid arrest because they were witnesses. This was a cold, calculated, premeditated murder. He was convicted of first-degree murder. And he also has a prior violent felony conviction from 1999. Can you break down how these factors might work for a jury?
Yeah, it's so heartbreaking when we go through these aggravants, but it's relevant to a jury in deciding what to do with this guy. And it's also interesting that in a penalty phase, Jesse, much of what comes in was not admissible in the underlying trial because it doesn't have that kind of relevance to those facts, but now it might.
So the evidence is different.
It can be, and that's what's interesting about a case like this, where you have a prior history that the jurors can consider. They're also going to be able to consider a positive history if one exists. Maybe that was what the attorneys were talking to this guy about over the weekend. But this is the kind of thing that we see in death penalty cases, is it's almost its own mini trial based on what do we do with this man who has now been convicted of these heinous crimes. Is it in fact strong enough to now kill him for it?
Well, why would a prior a prior act that he did, that felony conviction, why would that come in? But the fact that he was a part of a gang was too prejudicial. Can you reconcile that for me?
Oh, sure. And, you know, lots of times you look at what is the jury likely to become derailed by in deciding guilt or innocence. Not innocence, not guilty. Nobody's innocent. They're found not to. Cases have not been proved. But judges are so careful in the guilt phase. And they're so careful because certain things like gang membership are inherently prejudicial. And they've really got to link it to probative value that outweighs prejudicial effect. And many times, because of the connotations that we think of when we hear the terms gang member, gang activity, many judges err on the side of caution and say, unless, Miss Prosecutor, you can prove that's directly relevant to the allegations in this particular case, we're not going to let you talk about it. But things are different in the penalty phase now that that bias or that inherent bias or tendency to prejudice the defendant is no longer here.
I thought it was interesting for that conviction, they battle it out. The attorneys battle out whether that actually, well, did you actually see Mr. Toledo holding the gun in this case? We don't have to get into the actual details of what happened here, but this violent conviction, it's a violent felony, and they're debating whether or not what was his role in this. So I thought that was very interesting.
That's exactly one of the reasons why judges don't want to let it in during the guilt phase, because it distracts the jury and creates a mini trial.
I'm distracted. I'm already distracted.
You're right, over something else, and that's one of the other reasons that. So it's inherently biased, it's very prejudicial, and it really distracts the jury from the case at hand. So for both of those reasons, it's really tough getting some of that stuff admitted during the guilt phase.
Wendy, help me out. What are the mitigating factors here for this guy? I mean, the evidence against him in that conviction phase was so strong.
Horrifying.
So what are the mitigating factors?
Well, they may come up with things from his background. They often do in terms of humanizing the defendant. That's always the key. Remember, they did that in the Jodi Arias case, and in fact, there was one juror that didn't vote for the death penalty, saved her life, in other words. So too here, everybody's got mitigating factors in their background, or if not directly mitigating in terms of good behavior, explanatory behavior, facts and circumstances that many defense attorneys can use to explain why the defendant might have done what he did. Now, who knows the extent of what the jury is going to be seeing here, or how they're going to internalize it. Remember, jurors don't have to necessarily take at face value everything they receive in a penalty phase from either side. But those are the kinds of things in general that good lawyers present during a penalty to say, hey, this guy still has some value to his life. Here's the kinds of things he may be able to better himself with in prison. Probably shouldn't kill him. That's going to be the argument.
But do the defense bring out character witnesses saying, hey, Mr. Toledo's a great guy? Is that, you see anything like that?
That would be a little counterintuitive after he's just been convicted. And then, of course, he'd be impeached with, well, would it change your opinion if you knew that he'd just been convicted of killing? Yeah. That's dicey. It's easier to do such a thing in a guilt phase. But that's not to say that character witnesses can't play a role in a penalty phase. Many defense attorneys find character witnesses to talk about background circumstances that haven't changed and witnesses that haven't changed their opinion, even when they know about the conviction. Those maybe are powerful witnesses for the defense. On the other hand, you know, some jurors might think this witness is so biased that he or she is still willing to take the stand and say what they did, knowing what this man's just been convicted of.
Wendy, we're talking about human beings, right? We're talking about a panel of jurors that have to decide whether somebody lives or dies. How hard is it to get a unanimous jury verdict in this kind of case?
It's challenging, and it's particularly challenging in this day and age where you have such publicity surrounding cases like this. You've got arguments, and you know that jurors can never undo this, and it's something that they make sure they take very seriously. The toughest thing about picking a jury in this kind of case is when jurors admit that they would be able to vote for the death penalty. You know, I like to watch their faces and, you know, sort of as a body language expert some of the time, and you always see that degree of reluctance. It's got to be one of the most uncomfortable decisions, the most traumatizing decisions you'll ever make. I know many people that have served on death qualified juries and said they've never forgotten the day they actually were faced up close and personal with really having to make the decision whether to kill another human being. It can be very traumatizing, and in fact, jurors sometimes get together years after the fact, kind of as a support group, and talk about how hard it is. Having said all that, they do it all the time, because that's where the evidence leads.
And wouldn't it be easier in this kind of case? I mean,
much easier,
because of
Jesse,
given the facts?
Much easier. There are some cases where the facts aren't so up close and personal. We've all got kids, grandkids, you can relate to that. Killing children is an aggravant like no other. So it is a lot easier in a case like this, if that's the route they decide to go, than in perhaps some other cases where the special circumstances are not so up close and personal to individual jurors. Great question.
And killing them as witnesses is really, I think, the rationale behind it, if there even should be a rationale.
If there even can be, Jesse. This is one of the most heartbreaking cases. And you're right, the rationale, if you want to call it that, is one of the aggravants as well. So it's the behavior and it's the rationale behind the behavior. Really, right there is a double whammy if that doesn't convince some of these jurors. Having said all of that, I still go back to some cases where I've been shocked and surprised that it wasn't unanimous.
Well, again, we don't know. We don't know how the jury's going to vote in this.
Not yet.
We saw some really, really compelling and heartfelt and heart-wrenching testimony from the mother of Yesenia Suarez, as well as the father of Talia and Michael. How much does that affect the jury? Because that's, I mean, they were talking about that they're never going to be in these kids' lives anymore. These kids are not going to have a life anymore. They're going to miss them. The family is incomplete. And how much does that weigh for a jury?
Incredibly strong, Jesse. Those type of victim impact statements are so beneficial in terms of presenting how it really affected family members. You often have jurors crying in the courtroom when they're listening to this because they're considering their own family and how they would feel. Now, they're not allowed to do that necessarily if they're directed by the prosecutor. That's not proper. But they do internalize this because all of a sudden it's not words on a transcript. It's real people that were affected by the loss of children. And some of that testimony is hard to listen to because it's just heart-wrenching. And absolutely, that's the kind of thing that jurors need to consider in deciding, is this a case that's deserving of the ultimate penalty?
Wendy, if he is found to be, they want to sentence him to death, how long would it take for that to actually happen? I mean, I imagine you can appeal that, and that would be a process. So if he gets convicted, I mean, he is convicted, but if he gets sentenced to death by tomorrow, let's say, we're in 2017, what year do you think this would actually happen?
Well, it's an interesting question, Jesse, in a case where the defendant's initial response was, I don't want to present any mitigation.
Right.
It reminds me of some of the cases where after someone has been convicted of the death penalty, somebody like Timothy McVeigh, that basically has sought to expedite the process and not appeal. Now, I have no indication that's going to happen here. But it's hard to predict because there are so many grounds for appeal, and they're each unique to the facts and circumstance of each case. So we go back, the defense would go back and decide, well, is there anything that came in that shouldn't have? Was there anything that was litigated that should have been excluded, and maybe that would have had a different effect on the jury? that could take years. And it also, of course, depends on whether or not this defendant wants to pursue every one of those avenues. Maybe they pursue a couple, they decide others aren't worth pursuing. So it's hard to predict. But because he's young, he has lots of years of litigating appeals in front of him if that's the route he chooses to take.
35-year-old guy.
That's young.
Yeah, yeah. All right. Well, we'll have to see what happens in that case. And again, as soon as we do have live feed in that case, we're going to make sure to turn to it. But I want to move on with you while we have you here before we start off with our coverage. Jeffrey Willis. Okay,
yes.
Let's move over to that case. This guy, he's on trial. It's almost feels like 3 trials in one. He's on trial for the murder of Rebecca Blech, but he's also been charged with the disappearance and killing of Jessica Harenga, as well as the abduction of a 16-year-old teenager. He decided to take the stand yesterday. What did you make of that, which is so rare to see a defendant take the stand in these kind of cases?
It's often a prosecutor's dream to see the defendant take a stand in a case.
Especially in this kind of case.
In this kind of case, Jesse, where there's so many different types of evidence to toss against him. I got to tell you, the one thing that was a bit unnerving is the steadiness of his voice. You would expect somebody that decides to testify in the midst of all of these horrendous allegations would have sounded a little bit more nervous. I don't know if that helps him or hurts him, but he
Wendy,
seems so level-headed. I can argue that either way.
We're going to have to talk about Willis in a minute, but we do have our live feed in Toledo, so we're going to stick around. We have a lot